Imagine this, you are an Indian company spending crores on advertisement. Your sales increase, your brand grows, but suddenly the income tax department says you are not promoting yourself. You are promoting your foreign parent. Now pay tax on that. Sounds shocking. Let us decode one of the most controversial transfer pricing cases in India. Hello everyone, welcome back to the channel. Synergy Business Advisors Noida, your trusted business mitra, which deals exclusively with recent business related developments. LG Electronics Limited versus ACIT. This case is one of the most debated and influential ruling in Indian transfer pricing, dealing with whether advertising, marketing and promotion expenses incurred by an Indian subsidiary can be treated as an international transaction with its foreign parent. Background of the case: LG Private Limited, a subsidiary of a global brand, incurred substantial expenditure on advertising campaigns, marketing activities, dealer incentives. These efforts significantly increased sales in India, brand's visibility of LG. However, the tax authorities raised a critical concern. Was LG India promoting its own business or also creating value for its foreign parent's brand? The central issue was, can AMP expenses be considered an international transaction under Section 92B of the Income Tax Act? The department argued that the LG brand is legally owned by the foreign parent. Excessive AMP spending by the Indian entity enhances global brand value. Therefore, it amounts to a service provided to the associate enterprise. Department's position: the tax authorities contended that LG India was effectively promoting the foreign brand. No compensation was received for this benefit to the AE. Hence, a transfer pricing adjustment under Section 92C was required. They introduced the concept of excess AMP expenditure, which should be benchmarked and taxed. Assesses arguments: LG India strongly opposed this view. AMP expenses were incurred for its own business growth. Higher marketing spend directly led to higher sales and profits in India. There was no agreement with AE, no arrangement or direction from parent. Therefore, AMP could not be treated as an international transaction. Tribunal ruling. The tribunal delivered a landmark but controversial ruling. AMP expenses can be treated as an international transaction. Separate benchmarking of AMP is required. This meant comparing AMP spend with comparable companies, identifying excess spending, applying arm's length principle. Impact of the ruling: the decision had far-reaching consequences, expanded its scope of transfer pricing, covered even indirect benefits to foreign AEs, led to massive litigation, uncertainty across industries like FMCG, electronics, automobiles. Turning point: Sony Ericsson matter versus CIT. The Delhi High Court significantly refined the law. AMP expenses are not automatically international transactions. There must be an agreement, arrangement or understanding with AE. No presumption allowed without evidence. Additionally, and if AMP and distributions are closely linked, they should be aggregated and benchmarked together. Current legal position post Supreme Court developments. The Supreme Court has not fully endorsed the LG Tribunal's approach. It has allowed High Court ruling Sony Ericsson to prevail. Resulting position: AMP is not automatically subjected to TP adjustment. Evidence of arrangement with AE is essential. Greater emphasis is on substance over assumptions. Conclusion: the evolution from LG Electronics to Sony Ericsson reflects a shift from aggressive taxation interpretation to balanced evidence-based approach. Today, the law recognizes that mere benefit to a foreign parent does not make AMP expenditure an international transaction. There must be a clear arrangement or obligation. This is CA and IP Praveen Agrawal thanking you for watching. I hope this presentation will be helpful. Please subscribe to the channel for more such informative videos. Thank you.